Okay, we're back again here at allpointstv.com, and we are glad, we're elated, we are happy, we are so, um, what's the word here? We can hardly stand ourselves. We're so glad to see you out there, and hope you'll stay tuned for the next hour. We will be, I'm going to bring something in here that I have wanted to do for a long time, and that's to bring an alternative view in from the Heritage Foundation as to the impeachment process. And I wanted to read some of the things that they have to say about it, because I think they are pretty much a standard that's out there, and have a lot of respect for the work that the Heritage Foundation is doing. I just think we need to get a constitutional understanding in this country so that we can defend the framers and defend ourselves, because the framers set out a tone of action for the government. And we need to pay specific attention to it today, because I have to tell you that we are getting further and further away from the framers, and there is no salvation of this country if we don't begin to roll back toward what they had created in Philadelphia in 1787. And that ratification of that the following year should stand forever in the posterity of the country as they intended, because this was not a fly-by-night operation. They put almost full 3.5 months into the creation of the document, took it very specific care to bring it into existence. And they had not intended for it to ever go out, having a place for the amendment as a way of doing that which had not been in the purview at the time, because times will change, understandings will, conditions will change. And therefore, the document had to be at some point able to be altered to be extended, but not altered to the point where you are amending it so that it ceases to exist and do the things it was intended to do at its formative state. I wanted to bring in the Heritage Foundation, because I think the Heritage Foundation does a very good job in terms of some of the understandings they bring to the table about the process that I think we need to have a better understanding of the impeachment process. And I want to read some of the things that they have to say about it, because I think their claim is a little bit more. What I like about their claim is they go on both sides of the argument, and they will say that they haven't mentioned that they're talking about Article 1, Section 3, Clause 7, but that's pretty much where they're going with the can the president be brought to trial without going through impeachment, or does it take impeachment first and then to bring the president to trial, or a former president to trial? And that's the argument that they're claiming, and they're going to go to both sides and show that if it's on this side of the argument, here are the things that have to be argued. I would say that I come down on that the Constitution is clear enough that it requires a conviction in the Senate, even if the president is out of office, that he cannot be tried unless the president was impeached, and the impeachment can only occur if the president is in office. The trial, now the other thing I should say here is that the trial can occur after the president leaves office, but he cannot be impeached after he leaves office, because that is for the office holder at the time that he is in the office. After that is over, then the impeachment is closed off. The trial can continue after the president has left office, because the impeachment started while he was in office. Then if the trial happens thereafter, the trial can continue. That's what happened, by the way, with in the Trump case, because the second impeachment of Donald Trump, don't forget he was impeached twice. The second impeachment of Donald Trump occurred on the 13th of January 2021. He was only 8 days from 13th, so 7 days before the president was to step down. And it's hard to claim that there's an insurrection going on if the president, and when the time came for him to step down from power, and the president, so as not to have any claim made that he was staying beyond the tenure allowed under the 22nd Amendment, the two-term limit, to forego any claim that he was staying beyond the point of his tenure as president. And he was not submitting himself to the what is claimed to be the verdict of the voters. Trump left the office 30 minutes before the inauguration of Biden on the 20th of January 2021. So that you can't claim that you can't come and say that if he goes back in there again, he won't step down because he stepped down already one time. So that argument doesn't fly. But what I like about the Heritage Foundation is that in terms of the impeachment process, they go on both sides of it. And I want to read some of the things they have to say about it, because this is the best that I've come across. And let me start off by reading. Let's see here. Where do I want to start? Let me start here. The office he occupies at the time of his impeachment trial, and 2, disqualification barring the person from ever serving again in the federal government. Now, there are 2 things here that are being discussed: impeachment and conviction on the charge of impeachment. And then there's also the claim that be made if the person is to be barred from ever holding a federal office again. And what the Heritage Foundation is saying, and I do agree with this 100%, is that another trial has to be, and then there's another trial in the Senate that happens if the idea is then to go forward beyond the point of conviction and to forego any possibility of that office holder has been convicted to ever hold another office under the Constitution in the federal government. So the impeachment and then the trial, if it brings about conviction, then if you want to take the conviction and then forego the president having any further claim on any federal office again, then there's another trial that has to be held, but the standard is different between the 2. In the former, where the president is being impeached and then there's a trial of conviction, it takes 2/3 vote for the conviction to occur. If you come behind the conviction and then say that based upon that, the circumstance require to go forward beyond that, and we want to now forego any possibility of any return to the federal office, you then have to have another trial, and then that trial will require a simple majority vote rather than a supermajority is required for the conviction based upon the impeachment condition. So the 2/3 vote in the impeachment under Article 2, Section 4, where it says the president, vice president, all civil officers of the United States shall be removed from office upon impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors. Now, that would be a 2/3 vote required to then bring about the removal. To come behind that, and you don't have to come behind it, and sometimes you'll see where the removal was sufficient enough of a punishment where you didn't have to have, where you didn't seem to, well, they didn't invoke any further conditions, as happened in the case of the judge in Florida, Alcee Hastings is a case in point. Alcee Hastings was a judge, a federal judge in Florida, and he was impeached. I forget the vote totals, but it was an overwhelming number of votes in the House of Representatives, something like 306 votes or so in the House of Representatives. And you only needed a majority, which would have been 435, take one half of that, and the number would be what? One half of 435. I don't have get my pen out here to do some math. You got 435 members in the House, and that would be 218. Okay, it would require 218 votes of those that were there. And if the whole body is meeting, then it would take 218 votes. Everybody would be there because your representative would, you want to know why your representative was not there. And something as important as an impeachment of a federal office holder. This is not something that's very lightweight. This is a very heavyweight type of issue. And all the members want to be there because their constituents understand how they can be absent themselves from such a crucial way of holding politicians into account for what they do in office. So they're all there, and I would expect all of them to be there for that. And the full Congress is there because nobody has resigned, and the numbers of the full membership of the House. There are 435 members in the House, so 218 would be half plus one. So 218. I think in Alcee Hastings' case, if memory serves me correctly, there were 306 votes. So 218 were required, but the evidence was such that 306 voted for the impeachment, and then the 2/3 vote required for the conviction in the Senate. Because don't forget, Article 2, Section 4 says the president, vice president, and all civil officers of the United States shall be removed from office. There's no wiggle room here in terms of if you are impeached and then convicted, you don't stay because the command is shall be removed. So impeachment in the House, trial in the Senate, Article 1, Section 2, Clause 5, commanding impeachment, requiring a majority vote in the House, and then the command in Article 1, Section 3, Clause 6, the Senate trial being held, and the command here would be then, it would take a vote of 2/3 of the Senate. The day would be, I'm assuming all of them would be there in the full Senate, 100 members of the Senate. So therefore, 2/3 of the Senate, you would then require 6 or 7 votes to bring about the conviction. That's a super majority. So a very high bar for removal. You can see why, because you're removing the office holder, the single office holder that makes up of the federal government in the executive branch. It's not the same in terms of the removal of a judge because they're not the whole body of that branch. But you still have the circumstance of the 2/3 vote required for the removal. Okay, so they say here, disqualification barring the person from ever serving again in the federal government. It gives some examples here. In 1862, 1913, and 2010, the Senate took separate votes to remove and disqualify judges. West Humphreys, Robert Archibald, and Thomas Porteous, respectively. For each judge, a supermajority first voted to convict, followed by a simple majority vote to disqualify. So in each of the cases where there was the conviction in the Senate, a supermajority or 2/3 vote required for the expulsion. Then it says here, for each judge, a supermajority first voted to convict, followed by a simple majority vote to disqualify. The Senate defended this practice on the ground that the clause mentioning disqualification does not specify the requisite vote for its inquisition, although Article 2, Section 4 mentions removal as following conviction. Well, yeah, it does mention removal following conviction, because it says that the officeholder, after being impeached and convicted, shall be removed. There's no wiggle room in the fact that once convicted, removal does take place. The question is, what does that also set the circumstance for the disqualification for holding federal office again? And the answer there is no. The Senate in 1862, 1913, and 2020 considered that the supermajority requirement was designed as a safeguard against removal that, once satisfied, did not extend to separate imposition of disqualification. There is a separation of the removal from the disqualification. And what the Heritage Foundation is doing, very good job of, I would add, of making it clear that there are two separate trials that are required to do what amounts to two separate things. One is the expulsion from the office, the federal office, whether it's a federal judge or a civil office holder, or the president or the vice president, which would fit into neither one of those areas. Neither a civil officer of the United States, nor because the president of the United States is a elected office holder. So what the Article 2, Section 4 does, it takes out, when it talks about the civil office holder, it specifies that the impeachment process engages the president and vice president. That's why it says the president and vice president, and then it says, and all civil officers. That would be the ones the president appoints to the civil office, because the president appoints all of the civil officers. He appoints the members of his cabinet, he appoints members of the Supreme Court and other federal judicial courts. All those members are appointed by the President of the United States. And you notice in the language it says here, the president, vice president, and all civil officers of the United States. It does not say and all other. It excludes the president and vice president being civil officer by the fact that the language does not say other in the language. Listen to it carefully. The president, vice president, and all civil officers of the United States. If the president and vice president were civil officers, it would have said all other. There's no other in the language. So it's saying this: the president and the vice president, that's a separate quantification of who those office holders are. And it says, and all civil officers of the United States. That would then exclude members of the Senate and members of the House of Representatives, because they're not the president, they're not the vice president, nor are they civil officers of the United States. They are not, therefore, since it singles them out as possible impeachment and conviction targets, president, vice president, and all civil officers of the United States. It doesn't mention the members of the House and the Senate. And we know that because they're not civil laws of the United States. They are elected officers, state officers, sent to the federal government for the purposes of being the watchdogs of the states. You can see how the states were, in fact, trying, you relinquishing more power, but you're also at the same time watching over those that you've extended more power to, but you're sending watchdogs to Washington as the watchdogs of the state, so as to look over the machinations, the actions of the federal government, the president, vice president, and the civil laws of the United States, overlooking that in the interest of the states, and they're sending the representatives there to, in fact, overlook that, and they are and hold them responsible through the impeachment process, because they can bring charges against them in the House, which is the people's bodies, supposedly, and then tried in the Senate, which was intended to be the state's body. That's the brilliance of the document. And you see it being carried out in terms of the two presidents that have been impeached in this country. The three presidents have been impeached in this country. Andrew Johnson was impeached in 1868. And I would like to have seen that play out more than it did, because the question that was on the table in that case was whether or not, I already know the answer to this one. I think you could figure out the answer yourself. And in terms of the answer of this one, they had accused Andrew Johnson, the 17th president of the United States, of having violated the Tenure of Office Act that had been passed by the Congress, and the Congress was contending in that case that they had given their permission through the Senate confirmation of the office holder, Edwin Stanton, the Secretary of War, had been endorsed by the Senate and placed in his role by the Senate. By the way, Edwin Stanton knew they were coming after him, and what he had done, he had barricaded himself in his office, so they had to ferret him out of his own office by force. And they knew the radical Republicans wanted him out of office, so he had kind of, put up some barriers where they couldn't come and get him. And now the trial is now they're saying that they had the right to throw him, to protect him from being thrown out of office, because if they had given their permission for him to be in office, they're going beyond that, saying now as an office holder, the president had to come back to them to get permission to remove him from office. And that is all kinds of problems there, because that posed the same problem that Washington faced back in the day with the Jays Treaty, when they asked him for his records in the executive branch of government. And the claim they're making is that Washington had endorsed executive privilege, that he had exerted executive privilege in terms of telling the Congress they had no right to those documents. Now that they stop at that point and they make the claim that's executive privilege that Washington had invoked. I don't agree with that, and that's not what Washington was in fact doing. What Washington was doing here was saying that they had no right to the documents under the circumstance of they're making a demand for it. The documents were privy to the executive branch of government, except under the auspices of what was authorized by the Congress, in terms of them having, in Articles 1, Section 2, Clause 5, and Article 1, Section 3, Clause 6, the impeachment. Under the impeachment, the claim then could be made for the documents under that provision. Otherwise, it would be seen as an encroachment upon the prerogatives of the President of the United States. It's a very distinguishing argument to be made here about the president protecting the separation of powers. He's not invoking here as a claim is being made of executive privilege. Some people are saying it started back there with George Washington. I'm refuting that claim. That claim is untrue. And those scholars that are making that claim there need to understand a little bit more of what was really going on there. The president is protecting the separation of powers and saying they cannot, on their own, just demand the documents from the executive branch of government. Why? Because it goes across the lines that have been divided between the three branches of government, each one sanctimoniously inclined and endowed in their own branch to defend it against the encroachment of the other two branches. And this is an encroachment. Under those circumstances, if you're going to encroach upon those conditions set out in the lines of demarcation between the three branches of the federal government, you must do it through a constitutionally arised process, and that process is the impeachment process, where the president does not have any authority above the law. All his authority, like every other citizen, is under the law, but there are some peculiarities attached to it. And one of the attachments is that if you're going to go into that branch under the separation, you can only do that if you, in fact, bring about impeachment that's authorized in the document. And the Harris Foundation is making some very strong arguments here. I think very concrete arguments as to how that process plays out. The Senate defended this practice on the ground that the clause mentioning disqualification does not specify the requisite vote for its imposition, although Article 2, Section 4 mentions removal as following conviction. Yes, it does. The Senate in 1862, 1913, and 2010 considered that the supermajority requirement was designed as a safeguard against removal that, once satisfied, did not extend to the separate imposition of disqualification. The second question involved the proper sequence of impeachment and criminal proceedings. It is clear from practice, reading from the Heritage Foundation's understanding, it is clear from practice and judicial interpretation that officials other than the president may be convicted and even imprisoned before impeachment. The question, though, is whether a sitting president, though not singled out in the text of the Constitution, is immune from trial and conviction in the ordinary courts before impeachment and removal from office takes place. Now, that's a very interesting question here. The question is whether a sitting president, though not singled out in the text of the Constitution, is immune from trial and conviction in the ordinary courts before impeachment and removal from office. Can you do that to the president while he is in office is the question here. And here's what they say about it, the Heritage Foundation. The provision that a convicted official is, quote, liable and subject to indictment, trial, and judgment and punishment according to law gives rise to two constructions. Alexander Hamilton in the Federalist number 69 construed the clause as requiring that a president would first be impeached and removed from office and would afterwards be liable to prosecution and punishment in the ordinary course of law. That, I think, is what the Constitution requires. I think the reading of Article 1, Section 3, Clause 7 is the document is the part of the document which requires that. Now, the Harris Foundation will go on the other side of the argument and give the other side. I'm going to read that in just a minute. But I think that Article 1, Section 3, Clause 7 maybe I should read it. I think that is the correct way of interpreting that part of the let's see, Article 1, Section 3, Clause 7. Let me read that, because I think that reading is pretty much apparent. Now listen to this very carefully here. This is Article 1, Section 3, Clause 7. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. Now, the Heritage Foundation is raising a question that I don't think is appropriate under the language here, but I can understand why they are raising it as the other side of the argument to be made, and I have a lot of respect for them having ferreted that out. There is another argument to be made. I think that the language makes it clear that the conviction is necessary to the trial. That is, say, if you do not, in fact, impeach and convict, does that mean then that the trial cannot be held? And of course, the argument would be that if trial cannot be held unless the impeachment and conviction is taking place, then the president can get away with things that he would not be held to account. Well, the framers are dealing with a couple of things here. One of the things they're dealing with is that we don't want the people to wait in abeyance and wait until the president steps down and then get him. Because then all they have to do there, if they want to target a president who is carrying out the singularity of his responsibility as the president of the United States, he's the only office holder that is, in fact, he is the federal office holder in the executive branch of government. And you want to protect the president so he can make the best choices, even though they may be unpopular with the members of the Congress. And don't forget now, the Congress was looked at as being the branch of government, having been the only branch of the federal government in the Articles of Confederation. The fear was that the Congress would be the more likely of the body to be intrusive and oppressive in the federal government. Let's get past laws that would compromise the integrity of the rights of the individual. And we definitely see that happening for sure today in terms of how these rights are being encroached upon. If you weaken property rights, you will see an encroachment, because property rights are a basis of individual rights. If you don't have property rights, you don't have any rights at all. And there's an encroachment upon property rights because, to be honest with you, nobody owns the property in this country. They don't own the property they think they own in this country. That you can see that in terms. See, I contend that people that are rich don't own any more property than I own. I mean, I have 2 cars and that kind of thing. And if they have 2 cars, we are pretty much the same endowed. They may have more shoes in the closet, may have more coats in the closet, and things of that sort. But they don't own any more property than I own, because they don't own. The houses are more expensive, but they don't own them. And if they don't make the payments in terms of that, all that property goes back to the state. You don't pay the state taxes and things like that, then the ownership. the transfer of ownership is automatic back to the government can make a claim against it. So my reading of the article is that you have to have impeachment and you have to have conviction in order to then bring about the trial. If there is no impeachment and there's no conviction, the trial cannot be held after the office holder leaves office, or can be held to before the office holder is removed from office. There takes the conviction, impeachment, and conviction. The conviction then would bring about the removal, and therein, after removal has occurred, then the president can be put on trial. The question is whether or not the impeachment and the conviction necessary to the trial, and the contention here is that that is necessary to bring the trial. But the argument can be made on the side, and I think the Heritage Foundation is doing that, to say that the second question involved the proper sequence of impeachment and criminal proceedings. It is clear from practice and judicial interpretation that officials other than the president may be convicted and even imprisoned before impeachment. The question is whether a sitting president, though not singled out in the text of the Constitution, is immune from the trial and conviction in the ordinary courts before impeachment removal from office has occurred. And they're saying the special circumstance of the president, because he is the embodiment of the executive branch of government. There's no committee here. There is no large number of persons that occupy that branch of government as it does in the others. The judicial branch right now having on the Supreme Court 9 members, and then the federal courts having inferior courts that are under the umbrella of the impeachment and so on and so forth. There's a different circumstance there. But in the president's case, there's a special circumstance because of the peculiarities of his office. Okay, so the question is whether a sitting president, though not singled out in the text of the Constitution, is immune from trial and conviction in the ordinary courts before impeachment removal from office takes place. Their idea, the idea currently, was that the barring of the president from holding additional office was necessary to impeachment and conviction, and they had not done that through the first impeachment that had been brought about on the 20th of the failure of that was August the 20th, was in August of 1920. Give me a break. The trial of the president, talking about Trump here, fell through in August of 2020, not 1920. He may be an older president, but he's not that old. I made him older than I did what something that counts as what Reagan did, and taking age off the table when he's running against Mondale, when the issue was Reagan's age, and Ronald Reagan put that to bed by saying that he would not make issue of age in the election of 1984 by holding against Mondale his youth and experience. And that ha-ha moment took that off the table in that election. I mean, what could Mondale say after that had been made? You couldn't make an issue of the president's age anymore. It took that off the table because he had one up Mondale in that joke he made that made that a non-issue from that point forward. If you notice, it never was brought up in that election. They had not nailed down Trump's. They wanted to make sure this man couldn't run again. And they've not done that through the first impeachment because it fell through. So before he was stepping down from office in January, you would think they would just let the time play out. And he only had 7 more days before he had to step down anyway, and he would step down. They didn't have any doubt about that. He would step down because otherwise the military would have gone and pulled him out of office anyway because he'd been violating the Article 2, Section. Well, he would have been in defiance of the 22nd Amendment, which was passed in 1951, which was first proposed, by the way, against Franklin Delano Roosevelt in 1947, but it was ratified in 51, where you have the 2-term limit at this point, 2-term limit and 10-year top number of years you can serve in the presidential office. You can serve 2 full terms and then 2 years of another president's term. But beyond that, you're disqualified from holding office. Well, they had not stopped Trump from running again for the office, and they had not nailed that down, through which they had planned to do was to impeach, convict, and then go beyond the conviction to have another trial that would be a majority vote that would have secured that he could not run again. And if you convict him by a 2/3 vote, you certainly have the majority vote then to disqualify him from holding office in the future. They had not done that. So they're now having a second impeachment for the idea of they're going to now, with the former president, with the president at this time, he's still president at this point. But because he's still president, you can then bring about impeachment. And the trial, which was held after that, they thought he had been sufficiently weakened. I think they had ferreted out that the Republican Party would not feel as compelled by the Senate to stay behind Trump and could use the cover. The man had been impeached twice, and therefore they'd have the cover they needed to then bring about the conviction, then use conviction, then to have another trial, and then majority vote, there would be a disqualifying vote. That's what they intended to do. Otherwise, having the second impeachment had made no sense because he's going out of office anyway within 7 days. So what would be the second impeachment about? That impeachment was to bring about, eventually, if they could convict the president on the impeachment charge, they could then bring about disqualification for holding office in the future. This is a fear that they had about Donald Trump coming back later on and reestablishing himself as an outsider, holding that office again, and being a threat to those who are the insiders. And of course, both parties had some buy-in to that, but the Republican Party had to be a little bit more distant from it because people could ferret out why are both parties on the same side on this issue here of this outsider being blocked. And therefore, there was a little bit more of a problem for the Republicans to stand up for the conviction, even though Donald Trump, by the time that trial is held, is no longer in the presidency at that point when the trial was held, although he was in office at the time of the second impeachment. You cannot impeach an office holder when the officer is no longer in the office. That is very clear about the Constitution. And they are now impeaching a second time, but the intention here is to impeach, convict, and then disqualify. That's why the second impeachment would be held as late as it was during Trump's term. Because the second impeachment took place on the 13th of January of 2021. And they thought that the Congress had been so sufficiently enraged by what they called was an attack upon the Capitol. Everybody was talking about they were attacking our democracy. And so outraged that the Capitol building had been attacked. The House of Representatives had been the Congressional building had been invaded. Yes, by people walking into the building after being led into the building, and just walking around. Nobody is there's nothing being torn up. Some people put the feet on the desk. That should not have happened. But there's nobody tearing up anything in there, and that's one reason they have not shown those. I would like to see you show those tapes to the American people so they can see that the government is in fact conjuring up a lie that this was an insurrection, because when you walk into the building and you're not tearing anything up, you're not burning anything, you're certainly not going to have an insurrection. And there's no violence that's going on. Ashley Babbitt wasn't destroying anything when she was killed by Michael Byrd, who should be in jail for killing a disarmed person in cold blood. But this man was not put in jail, not put on trial, and in fact was celebrated for having done what he did on that date. I know that Jeffers, who is the minority leader in the House, is contending that 5 persons died. Hakeem Jeffers knows he's lying. There was only one death on January the 6th. No officers died on that day. And the claim that the 5 officers died is repeating what Biden said and what some of the others have said, and they know that's not true, because no officers died. Because no insurrection took place. There was no insurrection on January the 6th. That much is crystal clear. These persons walking, when Donald Trump has said to them, "I know you're going to go to the Capitol, and you're going to go there peacefully and patriotically." You can cut that out of the tape, but that's in the tape now. That's part of the speech they've cut out, that the January 6th committee act like those words were not uttered, and that this man had commanded the person go up there and stop the count of the vote and so on and so forth, and to stop the validation of the vote. What Donald Trump was saying is that the vote had not been taken yet, and the decision of who the next president was going to be after the 2020 election, who that president was going to be, had not yet been determined. And why would that be the case? Because it's not determined by the popular vote. This is the finessing of the understanding of the American people that think that when they go to the poll and vote, that the popular vote elects the president of the United States. The popular vote does not elect the president of the United States. The popular vote is a forerunner to the electoral vote, and the electoral vote elects the president of the United States. And why is that true? The electoral vote elects the president of the United States because the states elect the president. The states. This is not relinquished by the states to the American people. The states decide under Article 2 who the president will be under provisions in Article 2, Section 1, Clause 2 of the Constitution of the United States. The states make the determination through their state legislatures, was the intention. And that is corroborated by the Electoral Vote Count Act of 1887. That if there was an objection to the electoral vote count, if there's some question about the votes that the states have placed before the Senate, all the language in article, all the language in the Electoral Act of 1887 does is that it just simply says if there's an objection to the vote that's been sent there, here's what should happen in that circumstance. And that circumstance would have been if there's an objection in the House, seconded by the Senate, or if there's an objection in the Senate, seconded by the members of the House. If there is an objection to the integrity of the vote, then it is incumbent upon the 2 branches of the Congress to meet in their respective bodies to go through what the objections are and come back with a verdict by that House and a verdict by the other House, and they come together to decide what they're going to do about the objections. If the objections are determined to be unsatisfactory to the integrity of the vote, then the vote will in fact be taken. But on the 6th of January, the objections had to have been met by having each body go and to look over the objections before the validation of the vote could occur. They didn't do that. not because of Donald Trump having said go down there and stop it, but they did not do that because by having the what they call the claim of insurrection, the objection was never listened to. Now, I watched everything that was going on, and I will tell you this. They went behind the American people's back and passed the law that canceled out the Electoral Count Vote Act of 1887. And they did that by changing what should happen if there was a question about the electoral votes in the future. And that was to say in the future that if the votes are in fact sent by the respective states to the Congress, that vote then is to be counted by the vice president as a fait accompli, because then the new law passed underneath the visibility of the American people, passed in a way behind the American people's back, was to in the future make the vice president role ceremonial. But it was not ceremonial on January the 6th, 2021. That needs to be understood. The law has now been changed, but it was not changed on that date. It changed after that to make it appear, and what they tried to make it appear is that the law is retroactive, could be applied retroactively, and that's impossible too under Article 1, Section 9, Clause 3 of the Constitution. Retroactive laws are unconstitutional, and also laws of attainment are unconstitutional. That's why you cannot go back and change the law as they did in terms of the hush money, quote unquote, that Donald Trump paid, and then make that actionable in a court of law, because that would have been to go back and change the law so that it goes beyond the point of the statute of limitations, and therefore no statute of limitation. But in Donald Trump's case, you can't do that either, because of the fact that you cannot have a what's called a law of attainment. Now, a law of attainment is a law that, in fact, is passed to particularize who the law will, in fact, target. You can't have that, because then you're putting people underneath the law where they don't have the same protections. You don't have equal protection of the law, and that really is that really takes everybody, makes everybody subject to losing their rights, because if you can specifically target a person in the country and make a law particular to that individual, then who can be held secure in the United States? We all under that provision. If you can do that, and they can just simply pass a law that allows you to be targeted, then anybody that the government singles out as being a threat to its operational modus operandi, let's say, if they can do that, then everybody is under the gun potentially. So the Constitution, the framers were very meticulous about making sure the government could not do that, and they were doing that in terms of protecting the president after he leaves office, because I think the requirement in Article 1, Section 3, Clause 7 is clear that you cannot. They do not want the president to be unable to fulfill his role, creating enemies along the way, and then be targeted in the aftermath of that, either in office or then out of office. I think Article 1, Section 3, Clause 7 makes that very clear and establishes that. But there is another argument to be made, and the Heritage Foundation is making the other counter argument. Alexander Hamilton, in the Federalist Number 69, construed the clause as requiring that a president would first be impeached and removed from office, and would afterwards be liable to prosecution and punishment in the ordinary course of law. The argument made by many of President William Jefferson Clinton's case defendants during his impeachment and trial is that prosecuting president poses a unique risk not applicable to prosecuting the leaders of other branches, because the executive branch is the only federal branch overseen, reading here by the Heritage Foundation's point, by a single individual and thus prosecuting its leader, the president, uniquely risks paralyzing the entire branch of government he oversees. Now, that would be what I would say is, I agree with Hamilton here in the totality of Hamilton's argument. I don't agree with a lot of what Hamilton's arguments are, but I certainly think that is sacrosanct, the argument be made here. But there's a counter argument that the Heritage Foundation makes. I think this argument here requires some attention to be paid to it. The counter argument seems at least as strong. It says, first, the clause could be read not as requiring that impeachment precede prosecution, but as reflecting an expectation that impeachment generally might require that, but are not required to precede prosecutions. Now, that's an argument that the Heritage Foundation is saying that could be reasonably made. I think it could be reasonably made, but I think that it poses a question, a problem, if it is in fact made, because I think that the language is the implication, the clear implication of the language is that the two processes must be carried out as a protection against the president, because you have to think about what are they trying to achieve here by even putting that in the Constitution in Article 1, Section 3, Clause 7. Why is it there? Why did the framers come behind what they required in Article 1, Section 2, Clause 5, impeachment, and Article 1, Section 3, Clause 6, conviction? Why would they then come behind those two to make another claim of after the removal, and the removal will then you can come behind that and then make a claim about the furtherance of disallowing the office holder to hold office in the future? Why would they in fact do that? I think that what they're doing here is nailing down some bolts in terms of not going back, letting this person come back into power, but also a protectiveness against the office holder from being injured after either in office or leaving office, to then come back and require what would be your pound of flesh, because the people that some people don't like the decision making of the office holder while in office, and wait out his removal and then target him in the aftermath of him leaving office. The Heritage Foundation is saying that there's an argument to be made that you can in fact do that, but in a sense, then that if that be the case, you don't really need Article 1, Section 3, Clause 7, because you already made the impeachment, and the conviction would remove the office holder. So what's the rest? So why did they come behind that in another part of Article 1, Section 3, and then say that the office holder then can be voted as a disqualifying level after the removal has occurred? He can be further disqualified from coming back into the center of power. What is that there for then, if the removal has already occurred in Article 1, Section 3, Clause 6, but the verification of which is Article 2, Section 4, where the president shall be removed, the president, vice president, all civil officers shall be removed upon impeachment for and conviction of. But I do respect the Heritage Foundation for raising the issue, and it is something that has to be discussed and understood. If they could understand any of that in the Congress, we'd be, if they were even debating that in the Congress could understand it, we'd be better off, because it means that they're at least trying to get the Constitution right and what it orders them to do and what it orders them to be about in the judicial and the legislative branches of government. right now we're out here in the deep blue sea, and we have to get back to shores because that would get us back to where the framers were and what the intentions were. At least we need to have a discussion about that. Okay, that does it for the day's discussion, and hopefully we'll begin to have that discussion as we go forward. The framers have to be the centerpiece of all of our discussions. Other than that, we're lost. Until next week, I want you to follow your dream. If you don't follow your dream, you'll never know what's on the other side of the rainbow.